I'm Lauren Greer. I'm the Agriculture Rural Development Analyst with the Southern Office. I'm joined today by my colleague, Dr. Carolyn Orr, from the Eastern and Midwestern offices. I would also like to thank Lisa Hanairo for all of her technical assistance. So before we begin, let me cover a few housekeeping announcements. This webinar is being recorded, and it, along with the presentations, will be available later at csgmidwest.org and slcatlanta.org. During the presentations, all participants will be in listen-only mode, and that means you can't talk. But you will have a chance to ask questions at a later time, and so to interact with the speakers, you have two options. You can either click on the raise hand icon in the webinar console, and that will notify us that you have a question. And if your question has already been answered before we get to you, please click the icon again to put your hand down. Or you can type questions into the question pane in the webinar console. If you opt to ask a question verbally, you must enter an audio PIN. And if you choose to use your computer microphone and speakers, please test your system prior to asking questions. All right. So the Federal Food Safety and Modernization Act was signed into law in January 2011, and it aims to transform the United States food safety system from reactionary to proactive through some of the most significant revisions to our nation's food safety laws in more than 70 years. Today's webinar on the FSMA will follow up on previous FSMA webinars that we've held by examining the FDA's most recent action to implement the law, with a particular focus on the recently released supplemental rule proposals related to produce safety and preventative controls for human and animal food, and their implications for those in the food and feed supply chain. Our first speaker today will be Mr. Roland McReynolds, who will focus on how the changes relate to the concerns of smaller producers. Mr. McReynolds is the Executive Director of the Carolina Farm Stewardship Association. In addition to serving as the Executive Director, he directs the organization's food safety policy and serves as a member of the North Carolina Fresh Produce Safety Task Force and the USDA Fruit and Vegetable Industry Advisory Committee. Mr. McReynolds is an attorney by trade and is a recipient of the Marshall Memorial Fellowship. Our second speaker today will be Ms. Leah Wilkinson, who will focus on the issues as they relate to feed producers. Ms. Wilkinson is the Director of State Affairs for the American Feed Industry Association, and in addition to handling state government affairs for the Western U.S., she works with the association's feed ingredients, pet food, and equine committees. Prior to joining AFIA in 2010, she held various positions with Viagen, the National Cattlemen's Beef Association, and the National Pork Producers Council. The third speaker we have today will be Mr. Robert Hahn, who will discuss the impact on producers from a legal standpoint. He is a principal attorney at OFW Law in Washington, D.C., who specializes in FDA regulation of food and dietary supplements. His practice focuses on advising food firms and associations on various FDA regulatory issues, including FSMA compliance. Finally, we'll hear from Mr. Joe Reardon, who will provide a summation of the FSMA impact and discuss the effect the changes will have on state departments of agriculture. Mr. Reardon is the Assistant Commissioner for Consumer Protection at the North Carolina Department of Agriculture, where he oversees several divisions within the department, including those responsible for food safety. Prior to returning to service with the North Carolina Department of Agriculture, he served as a Senior Advisor for Federal and State Relations with the U.S. FDA. So with that, I will now turn it over to Mr. McReynolds.
Hi. Thanks very much for that introduction. As Lauren indicated, my name is Roland McReynolds with the Carolina Farm Stewardship Association, and I'll be speaking about issues for the local and organic food producers and food systems that may potentially arise from the FDA's proposed revisions to its FSMA rules. Just to talk a little bit about our organization, Carolina Farm Stewardship Association is an organization of farmers who serve the markets for local foods and organic foods in North and South Carolina. We have been actively engaged in FSMA really from the legislative process all the way through the regulatory comment process so far. and we were active in developing comments on FSMA's proposed rules on produce standards and preventive controls for human food last year, and we submitted over 200 pages worth of comments on those two rules. We also provide food safety training that is tailored to the needs of diversified and small organic and local food farms. So just by way of background, what we're talking about here relates to proposed rules offered to implement the Food Safety Modernization Act that originally came out in 2013. In January of 2013, U.S. Food and Drug Administration offered its proposed rules on produce safety standards and preventive controls for human food, and the comment period for those rules ended up lasting through November of 2013. The proposed rules on foreign supplier verification were published in July of 2013, not 2014, and the comment period ended in January of this year. And then the proposed rule on preventive control for animal feed was published in October of 2013, with the comment period ending in March of this year. And just by way of background, it's important to know that there is a federal court order from the Northern District of California that has set the latter part of 2015 as the final deadline for all 4 of these rules that we'll be talking about today related to FDA's supplemental proposed rules. So the initial proposed rules that came out, particularly for the preventive controls for human food, for animal food, and for produce standards, had a pretty galvanizing impact on agriculture across the United States. The National Association of State Departments of Agriculture called on FDA to start over on its proposed rules. Farmers, food and animal feed makers all expressed strong reservations about many parts of the rule, and this went, whether we're talking about small farms and small food companies to the largest food farms and food companies. And this outcry led FDA to very promptly, after closing the comment period on the produce and human food preventive controls rules, to pledge that they would be offering revised at least portions, that they would revise at least portions of those 2 rules, which brings us to where we are today. Earlier this week, FDA officially published in the Federal Register revisions of portions of the produce standards rules, the preventive controls for human food, the preventive controls for animal feed, and the foreign supplier verification rules. The comment deadline for all of these reproposals is December 15th of 2015. Now, it's really important to point out right here that these rules have only reproposed rules have only been available for public review and inspection for really less than 2 weeks. It's hundreds of pages of material, and in terms of analyzing the impact, it is very difficult to give anything more than a preliminary overview of the potential concerns that these rules might create for any sector of agriculture, but in particularly small farms, local food, and organic producers. And my discussion will only focus on the produce rule and the preventive controls for human food rule. It's also important to note that, again, FDA did not repropose the rules entirely, but simply identified specific areas where they were offering new language for consideration. So many important concerns that industry offered regarding other provisions of the rules aren't necessarily addressed in these supplemental rules that FDA came out with earlier this week. So moving into the standards themselves, with respect to the produce standards rule, FDA's changes relate to, 1, the use of manure and compost as fertilizer, 2, the use of and treatment of agricultural water in the production of crops, 3, the issue of the withdrawal of qualified exemptions for small direct marketing firms. As you may be aware, both in the produce standards and the preventive controls for human food rules, Congress mandated that farms and food companies with annual revenues of less than $500,000 and sales direct to consumers equal to more than half of those sales would be exempt from certain provisions of the produce standards and the preventive controls for human foods. FDA's proposed rules provide extensive procedures related to what happens when a firm or farm loses that exemption. So FDA's reproposals have provided some additional qualification there. The definitions of farm and farming activities have been offered, revisions have been offered, and FDA has added specific language related to the intersection of conservation practices and food safety practices. With respect to the preventive controls for human food, the supplemental regulations offer changes to the definitions of a farm and very small business. They offer clarification or further definition of the term very small business that may be exempt from certain provisions of the preventive controls rule. Again, addresses the withdrawal of qualified exemptions for those small and direct marketing firms. And there are 3 new areas added to the rules that were not specifically spelled out in the original proposed rules, and those are requirements for environmental testing, for supplier verification by food processing facilities, and for provisions for requiring end product testing. So in terms of what the local and organic food industry will be evaluating as we consider the impact of these reproposed rules, certainly issue number 1 is the definition of a farm, both in the preventive controls and the produce standards rules. FDA is expanding the range of farming activities that it's recognizing as farming and not food processing, so long as those activities are taking place on a farm. Existing federal regulations with respect to the definition of food processing capture a whole lot of the things that farms do normally with respect to their crops, things like packing, holding, storing those crops. Those right now also fall under the definition of manufacturing and processing. This was a major concern for the industry, for the produce industry, and with these proposed rules, reproposed rules, FDA is providing that certain harvesting, packing, and storage activities that take place on a farm will not trigger the requirement for that farm to register as a food facility, and therefore will not trigger requirement to comply with the preventive controls rules. The things that we will be looking at is trying to determine if FDA adequately captured the full range of those traditional farming activities that a farm can do without becoming a facility. And an important issue in terms of logic and in terms of regulatory consistency and the burden on state and federal governments to conduct enforcement of these rules is the question of why it would be that if a harvesting, packing, or storing activity takes place on a location other than a farm, why it would be considered a processing activity that would make that location, that establishment, a facility, even though the activity would be treated as a farming activity if it was taking place on a farm. With respect to the definition of very small businesses under the preventive controls rule, FDA is proposing $1 million in sales of human food as a threshold for qualified exemption from the preventive controls for human food rule. In the initial proposal, FDA had offered options of $250,000, $500,000, or a full $1 million in all food sales, including animal feed. Now they are proposing to specifically stick with the $1 million threshold and to exclude animal food from the calculation of that sales figure. Only 1% of the American food supply would be affected by this exemption, even if the qualified facility threshold is set at $1 million. So while this does allow certain facilities to be, quote, exempt from certain portions of the preventive controls rule, it's not impacting a significant portion of the American food supply. Other issues, as I mentioned, in terms of the preventive controls rule, these requirements to, under certain circumstances, conduct environmental testing at human food facilities is new, and the concerns are certainly related to what the cost burden this will create for small food processing facilities, and how will these testing requirements be enforced. There are also questions about if this is practical or scientifically valid as a preventive control from the scientific basis of preventive controls. Similarly, with product testing, the idea of requiring facilities to conduct testing of their the products that they are producing there certainly questions were raised in the initial regulatory round, say, to point out that testing by itself is not necessarily going to catch food safety problems. So what would the cost to industry be of having this requirement for product testing when it's not necessarily going to actually result in a lot of significant changes in terms of public health outcomes? And then the supplier verification requirement is also a new requirement that FDA is proposing in these supplemental rules, whereby if a facility is receiving food from either raw agricultural commodities or processed foods from other suppliers, FDA is proposing that the receiving supplier will have to take some sort of action to ensure that those suppliers are in compliance with FSMA. Again, we talk here, what are the costs? How will the enforcement be? Is this scientifically valid? And is this going to discourage a receiving food processing facility from buying from a firm or a farm that is operating under a qualified exemption from the Food Safety Modernization Act? FDA projects that the aggregate cost of compliance with these changes to the preventive controls rule will result in about a 10% aggregate increase in annual expenses for firms of less than 100 employees. Considering the cost of laboratory testing, capital investments, paperwork, and staff time, 10% certainly seems like a low estimate for what the additional financial burden will be from these new requirements. So again, that will be an area of further investigation and concern for the local and organic and small farm food community. We will also be evaluating the new process that FDA is offering in terms of what will happen if FDA decides to withdraw a firm or a farm exemption from the produce and preventive controls rule. Again, this was an area of significant concern in that the process laid out in the original proposal, from the perspective of a lot of folks in the industry, lacked due process. If FDA says, oh, you're no longer exempt from these rules for whatever reason, that's certainly going to create a significant burden for those small farms and direct marketing farms and food producers. So there was very strong concern that there should be better elaboration of the due process that would be in place before a producer would lose those protections, and so evaluating the appropriateness of FDA's new withdrawal procedures is going to be a very important part of the industry's review. Other areas of change in the produce rule, the use of manure and compost was the original proposed rules on the use of manure and compost required that for a farm to use raw manure as a fertilizer, there would have to be a 9-month withdrawal period between applying that manure and harvesting a crop from that field. And they proposed a 45-day withdrawal period between applying treated compost and harvesting crop from a field. There was widespread concern that there was an insufficient scientific basis to justify those withdrawal periods, and FDA's supplemental rules are removing the withdrawal period for treated compost. That is, if compost is treated to the requirements set forth elsewhere in the rule, there will be no withdrawal period between applying compost and harvesting a crop from a field. And they're postponing their decision on the manure withdrawal period. And they're specifically providing that the National Organic Program withdrawal standards, which are 3 or 4 months, depending on the type of crop, will be acceptable from FDA's perspective while it conducts further research and inquiry into this question. And finally, agricultural water. The farm industry, state agencies expressed a great deal of concern about about whether or not the science that FDA offered to support its original proposals on testing and treatment of water were in fact scientifically valid. The whole question of the treatment of agricultural water in production systems is incredibly complicated. The rules initially proposed didn't leave a lot of room for flexibility. The reproposed rules are very complex. It will require major consideration by the industry to understand the potential impact of these reproposed rules on agricultural producers of any size. And so this, again, is an area where the industry is certainly going to be investing a lot of time and energy trying to understand how these new approaches to water management under FSMA will actually impact producers. So, in conclusion, here again, we're very early in the process, and there is a lot of material to go through. I would encourage anyone at the state level to be paying close attention to FDA's operational strategy for implementing FSMA, a document which lays out how they expect to work with state agencies and with the industry to implement the FSMA rules, and that is going to be a really critical document. And that's the conclusion of my portion of the presentation.
Thank you, Roland. Well, I had to unmute myself. Sorry, people. We're now going to go to Leah Wilkinson. Leah?
Yes, thank you. As soon as I get control here. Okay. All right. Thank you all for the opportunity to speak to you today and give you the perspective of the animal food industry and what the rule has originally said and what the supplemental said, and a little bit about the American Feed Industry Association. We represent the entire feed industry, from livestock feed manufacturers, feed ingredient companies, pet food manufacturers, and then all the way down the chain through equipment manufacturers and allied industry into the feed industry. And we've been very active, just like Roland said, from everybody on the human food side, from the feed side as well, for the Food Safety Modernization Act as it was going through Congress, and then throughout the rulemakings and the time period, a couple years leading up to the rulemakings even. So lots of conversations going on. All right. It's not going forward for me. There we go. So today I just wanted to walk through a little bit about what was in the Animal Food Supplemental, what it does and doesn't say a lot of the times, some of our reactions, what was in the original proposal, things that have been changed, some questions that we still have going forward, and where things will go next. As many people may not be aware, in what FDA has started to call it animal food instead of animal feed. And when you're thinking about the Food Safety Modernization Act regulations as it applies to feed or animal food, it really encompasses the entire industry. All of the ingredients in the processing, whether it is a raw material that's coming from a mine, or, as a lot of people have learned, from a human co-product, human food co-product, to the regular traditional ingredients that you think for animal food, to the livestock feed, to the pet food, to the ingredients that are imported, as well as the transportation sector. And that's something we won't discuss today, but that is another rulemaking that is going on as we speak as well. So a little bit of background. In round one, as we like to call it, FDA issued for animal food, the current good manufacturing practices and the preventive control rule, as was noted in late October of 2013 after the government shutdown. We were delayed a couple of weeks from getting that release, but it finally came out at the end of October. And our comment period was a quick 5 months, and it closed on March 31st of 2014. And that was because of that court-ordered deadline that FDA was under to close all of those comment periods by March 31st of this year. So we were able to do our best in that short amount of time to review the regulations as they were proposed. This is the first time that good manufacturing practices are being proposed for the majority of animal food. We currently only have good manufacturing practices as regulations for medicated feed. And so this would be new good manufacturing practice regulations for the rest of animal food that are not medicated feed. Anybody that produces medicated feed will still have to abide by the current good manufacturing practice regulations that will be on the books, or that are on the books already. So that is a big, significant change for the industry and was a huge focus of the comments that we did submit, as this was the first time we were able to see those. When FDA was doing that, they looked at the human food rule and the human food good manufacturing practices as the basis for drafting the animal food rule. And that was a big concern to us because we know that animal food is different, not only in how it's manufactured, but also how it is applied and used out in the animal industry, from the difference of food served on a plate to us humans, to potential for cattle feed being dumped in a bunk or on the ground in some cases. And so we spent a lot of time covering off on those differences where we thought they needed to be a little bit more reasonable for the type of products and the end use of our products. So the main concerns we talked a lot about in the original proposal of who's covered, what exemptions were proposed, what facilities would be covered or exempt based upon the size that was offered. There was also initial discussion about trying to go for separate rules because the industry is so varied in the products that we produce in animal food. There was some initial discussion there, but the industry came together and decided that there was not a urge or a want for separate rules. Instead, to do just like the human food side has and try to write generic rules that applies across all of the different products that are produced, that we could do that for animal food as well, but just put in language like where appropriate or for the intended use. And so we made a lot of edits to that effect. And then compliance dates, and I'll talk about that in a little bit. And for round two, as was noted, the rule just came out. Our comment period closes on December 15th, just like the other rules. One of the big wins we did have is FDA has acknowledged that animal food is different from human food, and there were a lot of changes that they did accept based upon that, and that's a good accomplishment for all of us to get that acknowledgement from FDA. They did make some improvements in other areas. There's still more to go, we feel, and part of the challenge there, as Roland indicated, is we didn't see all of the changes that FDA intends to make or their responses to all of our comments yet. So it's hard to know if they just haven't made the decision yet to make some of those changes, or if they still need some convincing in some of those areas. And so we'll have to balance that out as we go through the rule as proposed, because they did propose the rule in its entirety, but they only asked for comment on the things that they've changed. And then I also wanted to point out, not only for animal food, but for all of the other three rules as well, FDA has posted what is a red line version from the original proposal. So you can see what they have proposed to delete and what they've proposed to add in the supplemental. And this is the link to the animal food red line. So just quickly wanted to walk through some of the changes that we have noted. And on the revised current good manufacturing practices. Again, this was significant for us that they were willing to republish these for us to see the changes that they have done, because this will be such a new requirement for a lot of the industry. And we did propose some, well, we basically rewrote this section for FDA in our comments. And so they have accepted most of that. They've rewritten a lot of it. They have tried to simplify the language and to make it more relevant to animal food. There's still some things in there that we see maybe not quite as relevant, but we're going through it still and looking at it. And so they definitely did try, and we will be continuing to evaluate that. One of the major things that was a carryover from the human food good manufacturing practices that the industry spent a lot of time on, because the burden was on our industry to prove to FDA why these changes needed to be made, was there was an original requirement in the good manufacturing practices that a sick employee could not have access to animal food. And while we can see the relevance for that in human food, we were not aware of any data that proved that a sick employee would make the animal food contaminated, that would then make the cow sick, that would then make the steak that you or I eat contaminated, that would make you or I sick as we ate it. So we had to go do a literature search. We contracted with the University of Minnesota to pull together that data to show that there wasn't any data there and no link to that, and FDA has removed that as a requirement from the good manufacturing practices. There also is an addition that they've done to the good manufacturing practices to try to clarify on the human food byproducts that are used in animal food. When FDA had originally put out the proposal, they tried to clarify that if you were following the human food good manufacturing practices, then that you necessarily didn't need to follow the animal food unless you were further processing it. That maybe wasn't the most clearly stated, so they've tried to state that more clearly in the supplemental, and so they've changed some of the language, added a section in 507.12, and then added this section to 507.28 into the good manufacturing practices, and that is part of their hope in providing some clarity of when it applies and when it does not apply. On the hazard ID and preventive controls, the industry was very concerned with some of the language that they were using here that was more of a HACCP, or a hazard analysis and critical control points language. They've gotten rid of some of that, but they've now talked about significant hazard and having to do that, look for that in your hazard analysis and then your preventive controls. So we will be looking at that very carefully to see what is a significant hazard, how do you determine a significant hazard versus a regular hazard, and what that all means for the animal food industry. And as Roland noted, we also have the same extras that have been added in the supplemental for supplier verification, as well as for product testing and environmental monitoring. On the product testing and environmental monitoring, we have noted that they put those in as verification of the implementation and effectiveness measures instead of as an original preventive control, which is what was first being looked at. And so that we think those are definitely more of a verification measure than they should be put in as a measure to prevent a hazard. You should be using those to look as a way to see if your controls are working. And then there they also tried to put in some flexibility because not all of animal food will need to be doing environmental monitoring. And so they've tried to add in some flexibility with some language that's there as appropriate to the facility, the animal food, and the nature of the preventive control. And so we will be looking at that very carefully to see how that will apply and will that allow the flexibility for when an FDA investigator comes in and questions why X company down the road is doing it and Y company here is not. Some other issues that we will be looking at, we continue to look at, there's a very high cost for implementing the regulations with a very low benefit to the industry, and actually FDA has had trouble and has stated such quantifying a benefit of implementing these regulations on the animal food industry, and now they've just added more costs by adding in these additional requirements and still not being able to prove any more benefit for the industry. Just like with produce and human food, there is proposed changes to the farm definition. Ours is a little bit different because they're asking questions about integrated operations or contract growing situations. And so how should those be covered? Should there be a tonnage level assigned to those? Exactly how should that be? So there's lots of discussions going on within the animal industry on that right now as well. And then for compliance dates, the original proposal had these same compliance dates, the 12 months for all other firms other than small and very small, post-publication, the small, which is less than 500 employees, for 2 years, and then very small, FDA has proposed to go with the option of $2.5 million or less in animal food sales, and you would have 3 years for compliance there. And that $2.5 million is less than 2% of the animal food manufactured in the U.S. And the one thing AFIA is talking about is, should there be a phase-in for these regulations, since the industry has not had good manufacturing practices in place before, and the human food industry has had 30-some years to get used to those. Could we get an additional year to put the good manufacturing practices in place first, and then do the preventive controls and hazard analysis a year later? So we're still talking to FDA about that, and that was something that was not in the reproposal that we continue to look, hopefully, that they will enact. So just to let you know, AFI is not waiting for the regulations to get done. We are currently in phase 1 of some training seminars that we're doing for the industry. We're going to start phase 2 next spring, and then we'll do phase 3 after the final rules are published in August of 2015. And then we do have certification programs as well that we offer for the industry that we have made changes to since we've seen the proposal, to try to get those that are certified in the programs up to speed, and that they will be light years ahead of other facilities in compliance that are not otherwise certified. So that's what I had for you today. This is just a link to the animal food webpage that FDA has for everything FSMA for animal food. So happy to take your questions when we get to that point.
Thank you, Lisa. And I've already got, thank you, Lee. And I've already got a half a dozen questions for you on some things, liability and brewers and some other things. Okay. We're now going to move to our legal expert on this. What's our liability? Are we going to get ourselves in trouble? And do we have to hire you, Robert, to come get us out of trouble when we sell something we shouldn't be selling?
I hope not, Carolyn. Thank you. Is my PowerPoint up?
Yep.
Okay. Well, my name is Bob Hahn. I'm a lawyer with a law firm here in Washington, D.C. I'm going to talk mainly about the first 2 rules. Let's see.
Go ahead and put it on slideshow. Just F5, okay. Robert.
Okay. Let's see.
Just hit F5.
Yeah. There it is. I'm sorry.
There you go.
Okay. Okay. So there are 4 supplemental proposed rules. As I said, I'm going to focus mainly on the produce safety and preventive controls for human food reproposals. As you've heard, these are 4 major regulations that FDA proposed last year. They're all highly interrelated with each other, and now FDA has issued supplemental proposed rules that change the 4 proposed rules and change their relationships with each other. So it's all very complicated. It's quite a complicated puzzle to sort through. FDA is saying that the changes they're proposing now will make the regulations more flexible, less burdensome, and more focused on food safety. And for the most part, I think that's true. However, there are new requirements as well that will make the proposed rules more burdensome, not less so. Starting with the produce safety reproposal, it narrows the coverage slightly of the produce safety regulation. It provides that a farm or farm mix type facility would be exempt if its average annual sales of produce is $25,000 or less. In the proposed rule, it had applied to average annual sales of all food. Now they're planning to apply that limit only to sales of produce. The reproposal clarifies the line between a farm and a facility. A farm, an establishment that is a true farm, is exempt from the preventive controls rule. If it's required to register with FDA, it's a facility, and then it becomes subject to the preventive controls rule. So the FDA is now saying that a farm, they're broadening the definition of farm. For example, the definition of harvesting would include field coring, such as coring lettuce in the field. That would not be a processing activity that causes the farm to become a registered facility. A farm, FDA now says, may engage in activities that are incidental to packing food, such as sorting and grading. A farm may engage in activities that are incidental to holding food, and they mention here fumigating crops, weighing, and mixing lots of the same raw agricultural commodity. And then a farm may pack raw agricultural commodities that have been grown on another farm, not under the same ownership. So a farm that does that is still a farm and is still within the produce safety rule, not under the preventive controls rule. A farm under the reproposal may engage in manufacturing processing of food, provided that one of the following conditions exist. All of the food that it manufactures, processes, is consumed on that farm or another farm under the same ownership, or all of the manufacturing processing activities that it performs consist of packaging and labeling of raw agricultural commodities, or the manufacturing processing activities it performs consist only of drying or dehydrating raw agricultural commodities to create a different commodity and packaging and labeling of the dried commodity. For example, if a farm grows grapes and then dries the grapes to produce raisins either on the vine or in trays using sunlight, FDA says that activity, that drying of the grapes to produce raisins, a different commodity, is akin to harvesting, and therefore the farm may do that and may package and label the raisins, and would still be considered a farm. However, if a farm cuts produce or applies sulfites to produce, that would be considered a manufacturing processing activity that is outside the definition of a farm. As Roland pointed out, there are significant changes to the agricultural water standard in the reproposal. This is a standard that applies to water that is used during growing of covered produce other than sprouts. And FDA is now proposing to use the EPA 2012 recreational water quality criteria. And it is a quantitative numerical standard for water quality. FDA provides that a producer that doesn't meet that standard would have other options. They could meet the standard by leaving a time interval between the last irrigation of the crop and harvest time, and applying a specific die-off rate of 0.5 log per day, or another rate that the farm has established through scientific data will achieve the EPA standard. Alternatively, a producer can meet the standard by leaving an appropriate time interval between harvest and end of storage of the crop, using an appropriate die-off rate or an appropriate removal rate for activities such as commercial washing of the produce. And that there are also proposed changes to the frequency of water testing that would be required. The use of the EPA recreational water standard is interesting. It still seems to be a standard that is pulled out of thin air. I'm not aware that there's any science on the use of that standard in agriculture. So even though FDA says that this is science-based, it isn't really clear why that is so. The reproposal would change the rules on use of biological soil amendments. As Roland said, FDA is removing the 45-day minimum application interval for treated compost, including composted manure, and they're reconsidering the 9-month interval for use of raw or untreated manure. And they're deferring a decision for the time being on what an appropriate interval would be for raw manure while they conduct additional research or risk assessment and take steps to encourage produce growers to transition to use of compost. And FDA also says that they're unlikely to object to farms that use the NOP, the National Organic Program, interval. For animal encroachment, FDA is clarifying in this reproposal that it would not require taking of threatened or endangered species, and it would not require, the regulation would not require exclusion of animals from outdoor growing areas or destruction of animal habitat or clearing of borders around farms or drainage. However, if animal intrusion does occur, as evidenced by evidence of animal feces or animal encroachment on a farm, the producer would still be required to evaluate whether the covered produce is safe to be harvested. Moving to the preventive controls for human food rule, again, FDA is expanding the definition of farm, and if you're a pure farm, you would not be covered by the preventive controls rule. So a farm under the reproposal may conduct activities expands the activities that farms may conduct and still be considered farms, and those activities are things like field coring, which would be under the definition of harvesting, packing and holding of food that is incidental, or activities that are incidental to packing or holding food on a farm. FDA is requesting comments on the current requirement that a farm be in one general physical location. FDA is aware that with divisions of farms into non-contiguous parcels and purchasing of non-contiguous parcels by the same farm, it isn't always the case today that a farm will be in one general physical location. It may consist of non-contiguous plots, and FDA says, should they therefore drop the requirement that a farm be in one general physical location. And then FDA, in the proposed rule, had a list of on-farm low-risk activity food combinations that would be exempt from preventive controls when conducted by a small or a very small business. And things like making maple syrup on a farm, producing honey on a farm. And FDA says they're thinking of expanding that list in response to the comments they received on the proposed rule, but they're not ready to do that yet. So we'll have to wait for the final rule to see those the expanded list. The the exemption for facilities that are solely engaged in storage of raw agricultural commodities other than fruits and vegetables for further processing or distribution. This exemption would apply to facilities like grain elevators. FDA says that they now will expand that exemption so that it applies to facilities that engage in other activities that are incidental to packing and storing of raw agricultural commodities, such as fumigating grains, weighing, drying grains, or applying preservatives or other chemicals to protect against pests or mold. The definition of a very small business, there were 3 options for that definition in the proposed rule. Businesses with less than $1 million, less than $500,000, or less than $250,000 in total annual sales of human food. And FDA has now said that they're going to go with the higher of the 3 amounts, $1 million. So that expands the scope of the definition. And since a very small business is considered a qualified facility, they would be subject to modified requirements and would have 3 years to comply with the final rule. FDA has also clarified that food facilities that ship byproducts for use in animal food would be subject to the preventive controls for human food rule, not the preventive controls for animal food rule. However, they would have to comply with CGMPs with respect to those byproducts while they hold them. And in addition, if the food facility does engage in any further processing of the byproducts for use in animal food, such as pelleting or heat treatment, then they would be subject to the preventive controls for animal food rule. As far as the requirements for facilities that are subject to the rule, there are some changes there. The hazard analysis that a facility performs would have to consider economically motivated adulteration. If there is a pattern of economically motivated adulteration of that food in the past, so if you're, for example, if you're purchasing milk ingredients from a country that has a history of melamine contamination of milk, you would have to consider that possibility in your hazard analysis. Otherwise not. FDA says, I'm sorry?
Okay, Bob, we're going to have to just break from you for a minute, see if we have a, can you hurry it up and finish it up real quick because we're running out of time?
Sure, sure. I think maybe I'll just skip to the rest of the slides. I think they're pretty self-explanatory. These are the new requirements for environmental monitoring, product testing, and supplier controls for covered facilities. I think I'll let you read those in your own time. The exclusion from compliance with CGMPs, the current regulations have an exclusion for establishments that are solely engaged in harvesting, storage, or distribution of raw agricultural commodities. This is the proposed revision to that provision. So it would exclude all farms, activities of farm mixed type facilities that fall within the definition of farm, holding and transportation of racks. And they've added hulling, shelling, and drying of nuts, and activities of fishing vessels that are not required to register with FDA. So I guess we'll leave it there and go to questions.
That was really good specific for people who you've answered several of the questions I already received, so that was really good specific. We're going to let Joe come in now and say why this is important to the State Department of Agriculture and our state legislators. Joe?
Yeah, well, thank you, Carolyn, and every one of the panelists here have just done an outstanding job reviewing not only the foundation of the rules as well as the recent release and the changes. I will say from a NASA perspective, we too have worked really diligently to go through the previous rules. We did review and provided about 200 pages of comments across the 7 rules. I'll highlight just 3 or 4 things here that I think was really critical today that you heard that you really need to be thinking about and encouraging you to review, as well as the panelists on the call today. A couple of things that I think is important to us. One is that there is some new testing requirements proposed in this for product testing, environmental testing. You say, well, Joe, why is that really important to us? Well, you as a company, there's also some foundation of law statements in FSMA itself that says that if there's subsequent rules require testing, then in fact some of that testing and those results from that testing would now be reportable to FDA. And that's in Section 202 of FSMA. And that's extremely important to know and understand what testing, if you find positives in your environment, do you have to notify FDA? Does that subject you to a more aggressive inspection by FDA or a state program? Do you also have to report finished product results as a result of this? And if so, who do you report it to? Who reviews that? And is that information reported to FDA FOIAble? A lot of information that your competitors may have access to if it's given to FDA under the provision of the Food Safety Modernization Act. Very important piece to companies with those two. Equally with supplier verification, something extremely important in how rigorous that's going to be as well. We're going to be looking and commenting on that, as NASDA has about 22 states and 60-some people working on this. Is something that we think is extremely important to, in addition to what you heard here today. And one last thing here that I think is probably as important as any of the changes they've made in the rules is that FDA has stated throughout this entire process that they plan to issue guidance, and this guidance will be Schedule 1 and Schedule 2 guidance. And so a lot of the language that they're using in the primary rule or the re-release of the rules really looks at words such as adequate, appropriate, reasonable, foreseeable, likely, known, those type of things that we anticipate, and FDA has clearly said that they're going to explain in greater detail in Schedule 1 or Schedule 2 guidance. From a lawyer's perspective, they're not actually rules, but at the same time they set a foundation of expectation of what it would mean to be in compliance with the language of the rule. So they are somewhat quasi-regulatory language because it sets a foundation. And so really what I'd say from our perspective here is NASDA's going to do its due diligence. We're going to go through these rules word by word. We're going to provide comment to FDA on this and post those. We're going to work with our partners here, with Carol, to make sure that our comments matches their comments. Our other association members that's been on the call today have done a wonderful job summarizing the changes. We too will be doing that. But I would call your attention to some of these final areas that I think needs clarity, needs additional comments, and I think that would be worthy of the time of all the associations and the individual growers paying attention to some of these areas. With that, Carolyn, I know you're running long, and I'll turn it back over to you for some questions.
Well, I have several questions that were sent to me beforehand, and that actually I'm going to pick out one important one for each of you. And the first one is, go to Leah. One of the issues several people are concerned about is the use of brewer grains, spent brewer grains by distilleries being given to farmers. And are they going to be under these same regulations now if you're a small brewery and you give away your spent brewer grains?
And so I will start, and maybe Bob, you can add on if I miss anything. Because they are considered a human food processor, because that is a component of the non-alcoholic side of what they do, they would fall under the good manufacturing practices for human food. And as long as they are not further processing those wet distillers grains or the spent grains that they have, as long as they're not further processing it, bagging it, whatever it may be. And they do have to follow that new provision 507.28 for that holding and distributing of the byproduct, basically to ensure it's not commingled with any garbage or trash or things like that. That's what they have to do. They do not need to fall under the rest of the animal food good manufacturing practices or preventive controls.
So that was a good change for those people that were concerned about that.
And it's more of a clarification, I think, than it is a change.
Okay. Roland, if a farmer is selling other farmers' products, in other words, a co-op or a farmer and brings other people's products to their farm, or helps sell them with theirs, commingles them. Is this going to, where does that put them? Previously, they thought that might put them as a processor. Where does that put them now? Have you looked at that?
Yes, this is one area that is covered in FDA's revision of the farm definition, and the way it looks right now is that they would permit a farm to pack, hold, store the raw agricultural commodities, fruit and vegetable produce anyway, of neighboring other farms without having to be without having to register as a facility. So yes, that change, again, that's sort of one of the traditional farming activities that FDA is recognizing now as a farming activity and not a food processing activity.
So another good change we can count. Robert, the Freedom of Information Act, Joe brought it up. In your impression, if things do come up, if the FDA does do something, would the information they found be available to everybody on Freedom of Information Act? Would the producer's information go to everybody if it was requested on Freedom of Information Act?
Well, if FDA takes, if records are available to FDA for inspection and copying, and FDA takes those records, they are subject to the Freedom of Information Act FOIA. That means anybody in the public can make a FOIA request for them. If they contain any confidential, commercial, or financial information or trade secrets, the company can and should notify FDA that it requests protection of those records and requests that they not be made public. And FDA will take those requests seriously, we hope.
Good point. If everybody would note that for their people. And Joe, last question I've got for you. What about the State Departments of Agriculture and Departments of Health? You think it's going to be just like the other FDA things that you guys would be responsible for inspecting operations in your own state through a contract with the FDA, or do you think the FDA is going to, as they do with the chicken and the egg industry, or do you think this is going to be something the FDA will be doing their own inspections?
Okay, that's a very good question. We really believe, NASDA does, that the states are best positioned to do these on-farm inspections, specifically as it would relate to the produce rule. We do, though, and we will be bringing to FDA a financial model, believe that the states are going to have the need for far more resources than traditionally have been made available through a contracting process. So I don't see any state in the nation, either whether it's done under public health or agriculture, doing it with an extension of an existing contract. I see a financial program that's far more robust, that gives those programs the resources to educate before you regulate, to work with their extension programs to provide a baseline, to look at developing a program on farms that is built around pre-assessment, voluntary compliance, on-farm assistance before you roll into a regulatory type program. So in summary, we believe the state should play a bigger role. We've heard that from FDA, but in doing so, we're going to have the adequacy of resources to distribute to the states in a way to make it functional and effective. We're going to have a program that works.
So as Joe points out, it's really important for our legislators and state officials to understand that the states will be involved in this, and that it's up to the states to push back on FDA as far as helping with the funding and the cost to roll this out properly so that producers are taught, not beaten. The training comes before the carrot, which comes before the stick. A copy of these presentations will be made available on the SLC website as well as on the MLC website. If you have any questions that we have not answered, please send them to myself or Lauren or Jason at CSG West, and we will get your answers for you, and we'll probably send the answers to the rest of the group because they may have those same questions. Let us know if you've enjoyed the webinar and if you need more information on this, or if you want to do resolutions, or if you think this is something that the Council of State Governments needs to take in as a policy advisement. I want to thank everyone for joining us. Thank our presenters for giving us of their time and their energy and their efforts and their abilities, and thank Lisa so much for her technical assistance. The webinar will now end.